Assalamu alaikum. I hope all of you are doing well. So today we will start our next topic, that is Statute of the International Court of Justice. So basically, International Court of Justice is the principal judicial organ of the UN, means United Nations. Ultimately, it is an important part of the United Nations. International Court of Justice was established in June 1945 by the Charter of the United Nations, and it started working in April 1946. The seat of court is the Peace Place in the Hague, Peace Palace in the Hague. The official language of the court are French and English. Then functions of the International Court of Justice. The main function of International Court of Justice is the settlement of the international legal disputes submitted by the states. What International Court of Justice do, if there is some sort of legal issue between two states, then one of the state will submit its case to the International Court of Justice, and then it is the responsibility of the International Court of Justice to resolve the issue, or we can say the matter. We can quote the example of Pakistan and India, that while there was issue of the state of Kashmir, and of course it is a legal dispute where both of the state claims their right on that particular area. So what India does, India has submitted a legal dispute, or we can say a legal document in the International Court of Justice about its authority on that particular area, and then the International Court of Justice decided that case according to the rules and laws of International Court of Justice. So these are basically known as continuous cases. Then there is giving advisory opinion on legal issues referred to the union, like advisory proceedings. Like most of the times the matters are not discussed, or we can say not submitted in the International Court of Justice, but International Court of Justice as a legal advisor, or we can say as an institutions which work for peace prevailing in the world. So it can give some kind of advice or opinion about the matter. Like if there is the dispute between Pakistan and India, and these disputes are like at a high risk of the war, then National Court of Justice has the right to give advice that both of the state must do table talks and resolve this matter uh, without any kind of war. Who can approach International Court of Justice? International Court of Justice is open to all the member states of the United Nations. It can be open to non-member states upon request. Like mainly all of the people, or sorry, all of the states which are the member states of United Nations can easily access to the National Court of Justice. But if there is a state and it is not a member state of United Nations, but it still wants to submit its case, or want to resolve its case by the International Court of Justice, then upon any kind of request from a member state, or if one of the member state request for that particular case, then non-member state can even approach the International Court of Justice for their matters, for their legal matters basically. It is not open to private individuals. Like if the matter is between one individual to another individual, then of course International Court of Justice will not uh, take that case, or will not resolve the matters between two individuals. Like the individual has to approach to its local court court of justice, to the court of its own state, for the matters. Then judges of International Court of Justice. The court is basically composed of 15 judges. uh, those judges are elected for the term of office of 9 years by the United Nations General Assembly and the Security Council. Like International Court of Justice is based on total 15 judges. It is the responsibility of the members of United Nations, like the member states. uh, of course they are the members of the General Assembly as well, and the members of Security Council. Of course, Security Council is also based on the member states, and they are responsible to elect those judges, and those judges are elected for a term of 9 years. There are 5 seats for Western countries, there are 3 seats for African states, 2 for the Eastern Europe states, and 3 for the Asian states, and 2 for the Latin America and the Caribbean states. So this is basically the division of International Court of Justice, on the basis of which the seats in the International Courts of Justice are divided between all the member states, so no member state can feel that they have no representation in the International Court of Justice. Or we can say this rule or law is basically adopted to make sure about the involvement, or about the we can say representation of each of the side in the International Court of Justice. Then resolution of issues in International Court of Justice, uh, like if there are any kind of issues, they can be settled by the parties at any times during the proceedings. Like if there is a matter and that is being resolved by International Court of Justice, like if the issue is being in the international court, and if the parties, like both the states, privately resolve that matter, then of course International Court of Justice can stop proceeding that case, and they can even resolve that matter on state level. International Court of Justice will have no right to ask them that until we won't decide uh, the results, you can't proceed. No, they can proceed at any time during the proceeding, and they can settle the matter by doing the table talks, even if the matter is in International Court of Justice. A state can discontinue the proceeding and withdraw at any point. Like if a state feels that their matter is not being discussed properly in the National Court of Justice, or they feel any kind of we can say uh, like they don't feel confidence on the decisions of the International Court of Justice, they can simply withdraw their case at any point. Then the court can deliver a verdict. uh, of course it is an international court, as the matter would be resolved, or the International Court of Justice will see any solution for the particular matter. So the court will deliver a verdict, and that verdict will be considered as an official verdict. A verdict is basically a decision, a detailed decision by the court. How International Court of Justice decides international disputes. Like if there is any kind of international dispute, then how International Court of Justice basically decides. International Court of Justice decide disputes in accordance with international law, as it reflected in international conventions, international customs, general principles of law recognized by civilized nations, judicial decisions, and writings of the most highly qualified experts on international law. Like, of course, International Court of Justice is a court that voluntarily work for international peace and to resolve the international disputes. So now there must be some kind of rules and regulations on the basis of which the matters would be resolved in the International Court of Justice. So International Court of Justice decide its cases on the basis of international conventions, like the conventions which are held between different states. On in those conventions, people basically decide that on what terms and conditions they will continue their relationships. Then international customs, Of course, there are some international customs that every state is ethically bound to follow. Then there are some general principles of law which are recognized by the civilized nations. Then there are some previous judicial decisions. On the basis of those previous decisions, International Court of Justice can decide the further decisions. Then there are writings of the, like, of course there are some scholars which basically write books or articles or journals on international law. So International Court of Justice can take reference from those books to take decisions as well. Then the court's judgment is final and without appeal. Like, if the court will give any kind of judgment, the judgment will be final and the state can't re-appeal for the particular matter. And if the state will not accept the judgment by the International Court of Justice, like ethically they are bound to follow the verdict by the International Court of Justice, but legally they are not bound to follow that particular verdict. So they will have no right to appeal. If they are not agree with that matter, then further they have to like back forward and they have to resolve that matter on table talk, or with the war, or whatever the way they will choose to resolve that particular matter. International Court of Justice is criticized for some of its functions. That of course there is no legal binding of its verdict, as I have already mentioned. That if one state doesn't want to follow the verdict or the decision by the International Court of Justice, they are not legally bound. When they are not legally bound to follow that verdict, then what happened, that most of the times the matters are not resolved and the status of International Court of Justice can be questioned. As we have seen the matter between Pakistan and India, that there is this verdict by the International Court of Justice about conducting a referendum in the Kashmir and asking its people if they wanted to go with Pakistan or if they wanted to go with India. But uh, of course, this like India is not bound to follow that verdict like legally, so that is why the matter is still not resolved. There is no legal binding of its advisory proceedings. Like, even if they give any kind of advice to the states, there is no legal bindings. Like, if one state wanted to follow that advice, of course they can follow it ethically. But if they don't follow that advice, they are not legally bound to follow that advice, and even they are not doing anything wrong legally. So this is what International Court of Justice is. uh, Thank you so much. Hope to see you in the next lecture.